Without further ado, let me introduce our speaker today, Thomas Wong. Thomas is a barrister called to the bars of Hong Kong and England. His practice focuses on commercial litigation and arbitration, domestically and internationally. He also has a significant level of experience in Hong Kong Chancery and insolvencies disputes. He is a member of a leading set of chambers in London and Singapore and Dennis James chambers in Hong Kong. He's also a fellow of the Charter Institute of Arbitrators and Hong Kong Institute of Arbitrators. He has been ranked as a leading junior in the legal 500 Hong Kong bar commercial dispute in consecutive years. So without further ado, let me take care of some housekeeping matters before I pass the stage to Thomas. Of course, I forgot to introduce myself. I'm Vod Chen, council member of the Hong Kong Institute of Arbitrators. And I'd just like to remind you that this webinar will be video recorded. And this recording will be uploaded to the Hong Kong HKIArb's website and YouTube channel. If you have questions during the webinar, the raise hand function and chat function will be disabled. If you have any questions, please type in your question in the Q&A chat box. And also, attendees are not allowed to unmute themselves. Okay, and also all of you are not allowed to start the video. In relation to CPDs, which you may be so concerned about, we will send an email afterwards once we receive a confirmation from, for example, Law Society of Hong Kong. And also, all of you, please submit an evaluation form to our administrator afterwards, please, okay? So unless you have other questions, without further ado, let me introduce Thomas. Thank you so much, Thomas.
Thank you very much, Ward, for that very kind introduction. And good evening, everyone. Welcome to this webinar on enforcement of foreign judgments and foreign arbitral awards in Hong Kong. In terms of tonight's outline, we will spend the first half of the webinar on the topics of enforcing foreign judgments and enforcing foreign arbitral awards, respectively, both under the statutory regime or the summary procedure and at common law. So we'll look at them first, and then we'll turn to the common grounds of refusal to enforce foreign judgments and foreign arbitral awards. And of course, these will be pertinent in the event that you are acting for a respondent. In terms of the common grounds for refusal, by common, I mean grounds common to refusing to enforce both a foreign judgment and a foreign arbitral award. There are 5 grounds. One is unfair procedures or no opportunity to present case, and then lack of jurisdiction of either the court or the arbitral tribunal, fraud, lack of finality, and public policy as a residual ground when you can't fit your objection in any of the more specific grounds. And then there are some other grounds of refusal which are unique to refusing to enforce foreign judgments and refusing to enforce arbitral awards, respectively. And these are listed there, and they will be relatively briefly looked at due to the time constraint. And then the last 10 to 15 minutes will open up for Q&A. So this is basically what we're going to do tonight. Moving on then to the first topic, we'll firstly look at the enforcement of foreign judgments first. And in this regard, there are 2 regimes that you would like to remind yourselves about or to look at. Firstly is a statutory regime, but this could be a misnomer because there is a statute, the Foreign Judgment Enforcement Ordinance for some foreign countries, and there is another statute for enforcing mainland judgments. So these are there are these 2 statutory regimes. As for common law regime, there is one. I've got a request to enlarge my PowerPoint. So sorry. Let me do the screen sharing again. Sorry about that. I should have been sharing this screen actually. Is this better? Yes. Yes. We were talking about the common law regime, and the common law regime is basically for recognizing and enforcing judgments where you don't find a relevant statute to rely upon. And the important point here is that if you have a statute that applies to your situation, go for the statute, because that's exclusive to the exclusion of common law enforcement. If you don't have a statute, then you have got to use the common law enforcement. So in a way, they are mutually exclusive. So we'll look at the common law regime first. Yes. So for enforcing under the common law, there are three main criteria. Actually, four main criteria. The first one I've talked about, that is that there is no statutory regime applicable to you. Now, the second criteria is that the judgment is for a debt or definite sum of money. So you're looking at a liquidated sum judgment. Things like specific enforcement, other things, injunctions. Unfortunately, you can't do that. The third criteria is final and conclusive. We'll look at what is meant by final and conclusive later. But essentially, even if one foreign judgment is subject to appeal, it could still be final and conclusive as long as the court that gave that judgment cannot set that aside or cannot order a retrial without an appeal court, for example. Then that would usually be final and conclusive. Now, the final main criterion is that the foreign court was with jurisdiction. Now, that is a question to be determined under Hong Kong law. And we'll look at that later. But in fact, essentially, the defendant must either have submitted to the jurisdiction of that foreign court or must have had some form of presence in the foreign jurisdiction, either by way of residence or by way of being present there. And in the case of immovable property, then the court was the court of the place where the immovable property was located. So that is the sort of jurisdiction that you're looking at. Now, once you have established that, then it will be up to the defendant or the respondent to enforcement to establish some possible defenses like lack of jurisdiction, fraud, public policy, and so on that we'll talk about in the next half of the webinar. But at the same time, it is important to remind ourselves that it is not open for the respondents to impeach the foreign judgment on the basis of merits. So, for example, the respondent could not say that, well, I think that the foreign court got it wrong. That is not permitted as a ground. The Hong Kong court is only concerned whether the foreign court, well, overall, whether the foreign court's procedure and process was fair and whether there was substantial procedural justice done to the defendant. So I've already foreshadowed this slide. So for the party seeking enforcement, you need to prove final and conclusive between the same parties, and then the judgment being determinative of the relevant substantive matters, and the foreign court had to have competent jurisdiction. So I've covered that. Now, and I've also foreshadowed that it would be for the respondent resisting enforcement to prove any of the recognized grounds for resisting enforcement. So fraud on the part of either the plaintiff in the foreign proceedings or the foreign court, obtain a procedure which offends against the Hong Kong court's notion of substantial justice, and offending against public policy, that sort of thing. In terms of the procedure, in terms of how you actually go about applying for enforcing a foreign judgment under the common law, you basically start off with an originating process. For example, a writ accompanied by a short statement of claim, proving only the essential matter. So who are the parties? What the foreign judgment was, what the foreign court was, and then the sum adjudged, and the other matters that I've covered that you need to prove. So it's very short, and you don't need to go into the actual underlying substantive merits because, of course, that has been dealt with by the foreign court. And then if the respondent does not resist, then you get your default judgment or whatever. If the respondent turns up and resists, then you usually go for summary judgment, and it will be usually it will be under the usual order 14 procedure. You've got your summons for summary judgment, you've got the affidavit, and then after exchanging affidavits by the parties, then there will be a substantive hearing, and hopefully your case will be a straightforward one without a. Hopefully the respondent will not be able to raise a tribal issue in relation to things like fraud, things like offending Hong Kong public policy, things like the foreign court had no jurisdiction, etc. So those would be the things that the respondent could potentially raise in an attempt to resist summary judgment. Of course, if the respondent, unfortunately, to the winning plaintiff is able to raise a tribal issue on any of the grounds recognized to resist enforcement, then in theory, the case will have to go to trial. But of course, it also depends on the amount of the amount involved in enforcing your foreign judgment. Of course, if it is a huge case, then you might actually want to fight that trial. But in some of or most of the cases, that trial may or may not be worth fighting for. And so I think the court will also bear in mind the fact that if they refuse summary judgment, that basically means refusing enforcement effectively. Now, a couple of final points on the time limits. The writ for enforcing this foreign judgment need to be issued within 12 years from the date of the entering of that foreign judgment. And then there is also a time limit for executing the Hong Kong judgment that recognizes the foreign judgment. And that is 6 years. And so, of course, you need to bear in mind these time limits. Otherwise, the Hong Kong court, I mean, you'll be time barred even in Hong Kong. Now, those are really what I want to say in relation to enforcing a judgment under the common law. So we now turn to the statutory regime. And this statutory regime applies to non-mainland judgments. So, and specifically to judgments in these jurisdictions that are listed in the slide now. And the regime is called Foreign Judgments Reciprocal Enforcement Ordinance, HKIArb, Cap 319. And there are two groups of foreign jurisdictions that are listed here. The first group are basically British Commonwealth jurisdictions. The second group are non-British Commonwealth jurisdictions. Now, for the non-British Commonwealth, Commonwealth jurisdictions is simple, straightforward: Belgium, France, Germany, etc. And these fall within the regime in a straightforward manner. But for the Commonwealth jurisdictions, there is one additional hurdle as a result of the handover, and that is you have got to show, either by way of actual evidence or by way of, for example, a previous Hong Kong case deciding the points, that jurisdiction still accords reciprocal treatment to us in terms of recognizing and enforcing a Hong Kong judgment in that British Commonwealth jurisdiction. And that is by virtue of Section 2A, subsection 2, subsection B of the IGCO, which modified the default rule such that all previous favor, if you like, that had been accorded to Commonwealth jurisdictions, simply by virtue of their being Commonwealth jurisdictions, have been removed as a result of the handover. So you have also got to show that, for example, Australia accords reciprocal treatment to Hong Kong judgments. And that could be established by, as I've said, citing a previous Hong Kong case to decide the point, or actually showing to the court that, look, Australia, or this particular state of Australia, has this statute that recognizes Hong Kong judgments. So this is something to bear in mind. Now, you will see that the theme for enforcing a foreign judgment under the statutory regime is largely similar to the theme for enforcing a foreign judgment under the common law regime, in the sense that you've got to prove that this is a judgment of that jurisdiction, and of course in this regime there is an additional requirement that the court must be a superior court of that jurisdiction. So firstly, it is a judgment of that foreign jurisdiction that is given by that superior court. And secondly, similar to this common law regime, it has got to be final and conclusive. And then thirdly, it is also going to be a liquidated sum judgment. So again, injunction, specific enforcement, that sort of thing, unfortunately, you can't do it. There is also an additional requirement that actually would also apply to the common law regime, because Hong Kong courts are not supposed to enforce foreign penal statute or foreign tax statute. So you've also got to show that as part of the affidavit in support under the statutory regime. And then there are other requirements that the judgment has not been wholly satisfied, of course, and that it can still be executed in the original jurisdiction. Once these are satisfied, then the Hong Kong court would register the judgment, and then so it is just a simple registration process, and then it will become enforceable as if it were a Hong Kong judgment. And then, of course, you will then serve the papers on the judgment debtor, and then there are these grounds that the judgment debtor could prove to set aside enforcement or registration under the statutory regime. So there are two groups of grounds of objections. The first main group of grounds of objection is that you haven't even satisfied the requirements of the statutory regime. So requirements of the registration were not in fact met. And then, or for example, the judgment has been wholly satisfied, it turns out. And then there are the other grounds that are common to the common law regime. So for example, the foreign court had no jurisdiction, and then there is this specific ground that even if you have fairly served the process, the foreign process, on the defendant, he actually didn't receive it, or he actually didn't have enough time to respond to the foreign litigation, and he in fact did not turn up at the foreign proceedings. Now that is a ground that is also available to a defendant under the statutory regime. Judgment obtained by fraud, contrary to public policy, and so on. Now, again, of course, it is for the judgment debtor to show any of these grounds. And if the judgment debtor had evidence to show that actually there are effectively conflicting foreign court judgments on the same subject matter, then the court will have to have the discretion. The Hong Kong court will have the discretion to stay enforcement of this foreign judgment that you have registered to see what it is all about. And that's the last point on this slide. Now in terms of pending appeal, so what happens if in the process of enforcing in Hong Kong, actually in the foreign jurisdiction, the foreign judgment is subject to appeal? It doesn't mean that the judgment the enforcement in Hong Kong will be set aside necessarily. Of course, the Hong Kong court has the jurisdiction to just set aside the registration and not allow you to enforce it for the time being. Or the Hong Kong court could just adjourn the application to adopt a wait-and-see approach. So it is up to the Hong Kong court to decide how to handle it. Again, there are these time limits that you may wish to refer to, and I think that is more to do with situations where the defendant actually has assets in the original foreign jurisdiction, and then your client is trying to enforce it in the foreign jurisdiction, and forgetting about Hong Kong for the time being. And then after a few years, your client discovers that the original jurisdiction's enforcement is not going anywhere, and so your client wants to turn to Hong Kong to enforce it, and then finding that you are nearing the end of the Hong Kong time bar. So there are these time bars, and if your client has sat for a while before turning to you, then these are the time bars that you need to remember. Now that deals with enforcing foreign judgments under the FJREO. So there is another statute called the MJREO that sort of mirrors the FJREO that deals with mainland judgments. But there are some twists. So on the one hand, there are some similarities. On the other hand, there are some twists. So what are similar? Effectively, what are similar is that mainland judgments given by some higher courts, if you like, as set out here, like the Supreme People's Court, like the Higher People's Court, or the Intermediate People's Court, or even some recognized basic People's Court, those judgments, like the superior courts in those FJREO countries, would be enforced under the MJREO. So that's similar. The second similarity is that it also deals with monetary judgments. So it has to be a monetary judgment. But the difference is this. The main difference, and that is the main limitation under the MJREO, is that you have got to base your original claim on an exclusive choice of court agreements. So not only have you got to have a contract beforehand, you have got to have a contract with a jurisdiction clause that says mainland courts have jurisdiction, but you have actually also got to make sure that that is an exclusive choice of court agreement that says only that mainland court or only those mainland courts have the jurisdiction to adjudicate on disputes arising out of or in connection with this agreement. And those mainland courts will have to be either the Supreme People's Court, Intermediate People's Court, etc. So that's the major difference and the major limitation to the MJREO. And these points are laid out in this particular slide already. Now, so in terms of what you need to prove in an application for enforcement under the MJREO, you have got to prove what I've just said. So you have got the exclusive choice of court agreement. You have got to show it is final and conclusive, enforceable in mainland China, orders the payment of a sum of money against liquidated damages, and the relevant date is an additional requirement, and that is the 1st of August 2008, because that was the time when the MJREO was first enforced. So of course, 10 years ago, this particular time limit was more significant. Now, as time passes, I think most, if not all, of the applications would have satisfied this 1st of August 2008 hurdle. And then there is another time limit that says that applications for registration must be made within 2 years, effectively from the date of the judgment or from the last day. So in other words, 2 years from either the date of the judgment or from the date of the deadline specified in the judgment for paying that sum of money, whichever is the later. And you can make this application by way of ex parte application and with affidavits addressing all these matters, and then it will be registered, and then you'll serve the papers on the judgment debtor, and then again they will be able to prove some of these defenses for review for objecting to your enforcement. Again, there are two main groups of grounds of objections. The first group relates to the fact that you haven't satisfied all the requirements of the MJREO. So these would be bracket 1, bracket 2, bracket 3, and possibly bracket 4. So if your judgment has been wholly satisfied, then of course there is not even a ground for enforcing anything. And then from bracket 5 onwards, these are the grounds that are in common with the other grounds of objection. So, for example, the mainland court actually had no jurisdiction, or in terms of ground 5, actually the courts of Hong Kong had exclusive jurisdiction instead, rather than the mainland courts. So you have abused the procedure. And then ground 6 is that the defendant was actually not summoned before the mainland courts, or wasn't given the requisite time to defend the mainland proceedings, or the judgment was obtained by fraud, or actually there had been a prior arbitration proceedings or prior arbitral awards, etc., or enforcing the judgment is contrary to public policy, or the last ground being the judgment has been reversed or set aside under the mainland appeal procedure or mainland retrial procedure. So these are for the respondents to make out. Now, given the major limitation of the MJREO that I just talked about, and that is, of course, the requirement of an exclusive choice of mainland court agreements. It has finally now been sort of resolved by this new ordinance. Now, this is a separate ordinance. This is a new ordinance called a mouthful, Mainland Judgments in Civil and Commercial Matters Reciprocal Enforcement Ordinance, which I will call CAP 645. And that is a separate ordinance that it has not taken into effect yet, but probably it will take into effect later this year, actually in the first half of this year. And so for the first time, firstly, you will no longer need to have an exclusive choice of mainland court agreement. And secondly, it has actually expanded the scope of mainland judgments recognizable under this regime to non-monetary judgments, to non-contractual judgments, and even for judgments for payments of sums of money in respect of compensation or damages awarded in criminal proceedings. So it is like a monetary judgment, a sort of a civil judgment in relating to a criminal or arising from a criminal set of proceedings on the mainland. Even that sort of judgment could be, in principle, be recognized and enforced in Hong Kong. But of course, at the same time, you'll note the last main bullet point on this slide. These particular mainland judgments are excluded. So insolvency, some family judgments, some intellectual property judgments, not all. So these would be excluded. But most judgments could, in principle, be enforced under Cap 645. And what is more, non-monetary relief. So judgment for non-monetary relief is for the first time recognizable and enforceable under this new ordinance, which of course goes beyond even the scope of the FJREO. If you remember a few slides earlier, we were talking about the other foreign jurisdictions like Belgium, Israel, Germany, and other and then all these Commonwealth jurisdictions. Now, even under that well-established FJREO regime, you can't enforce non-monetary relief judgments, whereas in this regime you can. And I have set out in this particular slide the difference, and I'm given to understand that this particular webinar and the slides will be uploaded subsequently. So I've just placed the table here for your convenience. Now, so all these dealt with. So I've now dealt with all the enforcing of foreign judgments. So now turning to enforcement of foreign arbitral awards. So we are talking about arbitration now, and the takeaway from here is that essentially whatever arbitral award you are seeking to enforce in Hong Kong, there are basically two substantively the same procedures that you could choose. Now these are not necessarily mutually exclusive in the sense that I will elaborate later. But you have the summary procedure, which is like registration procedure, and you could also alternatively bring a common law action on the basis of your arbitral award. Now they are not exclusive in the sense that you could, for example, have a foreign arbitral award that you register first under the summary procedure, and then you discover that actually registration by entering Hong Kong judgment in terms of the award will not do your client any good or will not be practically beneficial to your client. So you would want to abandon that, and then you would want to try to sue on the arbitral award, which will then give you a wider range of relief apart from what you have already been awarded under the arbitral award. Now that sequential alternative enforcement is possible under these two regimes. So in that sense, they are not mutually exclusive. But of course, you cannot double recovery. You cannot do double recovery anyway. And what that means, therefore, is that if you do what I've just said, so summary enforcement, and then when summary enforcement becomes meaningless, you go for common law enforcement. Then if your common law enforcement succeeds, you have got to voluntarily ask the courts to set aside or to effectively cancel your summary enforcement. So you can't do double recovery. So in that sense, they are exclusive, but not in the sense of FJREO, then you can't do common law, that sort of exclusivity. Now, firstly, we'll talk about the summary enforcement procedure. So again, it is ex parte. You make your application by ex parte originating process and affidavit to the judge in charge of the construction arbitration list. Of course, now is Madam Justice Mimi Chan, and there are these 7 things that you need to cover in your affidavit. So very, very straightforward arbitration agreement, original award, and then your usual last known address, and then the respondent's details, and then of course you also got to verify that your award has been unpaid, and then if your award is not in Chinese or English, then you've got to enclose a translation. So all this very straightforward, pretty much like the summary enforcement, or pretty much like the enforcement of foreign judgment under the statutory regime that we've just talked about. This is just a reminder that as with any other ex parte procedure, you've got to make your full and frank disclosure. So if there is anything that is relevant to the court's exercise of this discretion in terms of, oh, actually, the original award had some irregularity. I don't know what it is, but there is some irregularity that the court should be aware of. Then you've got to disclose that, because otherwise, if the other side turns up at the inter partes stage and then they rely on that, then your enforcement may be set aside, and you'll have to pay costs, etc. So that is just a reminder that you don't try to do that. And then again, for the respondents to enforcement, there are a raft of grounds to resist enforcement, which are not unlike the grounds for resisting enforcement of foreign judgment. So, for example, if there was fraud, if there was substantial procedural unfairness, so you didn't have a fair chance of presenting your case, you weren't served with the papers, or even if you had been served, there wasn't just enough time for you to make any sort of meaningful submissions or defense, that sort of thing, then the respondent could prove. Of course, the hurdle would be quite high under the under the arbitration regimes, because Hong Kong is quite pro arbitration. So the relative burden on the defendant would be relatively high. But at the same time, if you are the applicant for enforcement, if you are aware of any of the facts relevant to this, then you've got to disclose, and then hopefully the court will still be with you. Now, again, there is an important point here, that the Hong Kong court is not concerned with the correctness of the arbitral award. So even if on the face of it, there is what you would consider to be an obvious error, that is not a ground of not enforcing it. So of course, the proper procedure for the respondent would be to go back to the arbitral tribunal to say, look, you've made for example, a calculation mistake there. The award is not for $100,000. The award is only for 90,000, for example. Then you go back to the original tribunal and things. Now, in terms of the action on the award, this is not the summary procedure. We have now covered the summary procedure. This is the common law action on enforcing arbitral awards. Now, when you want to use this, would be situations where the original award was for something, awarded you something that is no longer meaningful to you. So, for example, the obvious example in the leading case of Eaton would be the award said that the defendant or the respondent should continue performing the agreement. Now, in circumstances where actually the subject matter of the agreement has ceased to exist, for example, that relates to some landed property that has been sold onwards to some innocent third party. So you no longer have the landed property. You no longer can continue performing the award, performing the agreement in any meaningful way. So in those circumstances, merely registering your award and entering Hong Kong judgment in terms of the award will not do your client any good, or will not be meaningful or beneficial to your client. Then you would want to consider whether you should instead bring a Hong Kong common law action on the award, and that is based on the award, but actually based on the breach by the respondent of the implied promise to perform the award. So that is essentially a breach of contract claim. So there is an implied obligation when you enter into an arbitration agreement that you would comply with the arbitration award. And in failing to do so, the respondent is said to have breached that implied obligation. So because the root or the source of the obligation is the implied promise to perform the award, therefore the remedy that is available to you is not limited to the scope or to whatever that the award itself says. So, for example, in the example that I've given, if it was the defendant that have caused the subject matter of the landed property to be on-sold to some unrelated innocent third parties, then the breach of that implied promise to perform the award could mean, for example, that the defendant should be awarded against damages in the amount of the landed property. Now, if you think about it, the damages and the compensation that could be awarded under a common law action are not stated in the award. The award just says continue performing the agreement. The award didn't award you any money as such, but a common law action could go beyond that and award you money. That is why sometimes you may actually have to go under this route. So I've cited the leading case in this regard, the Eaton case, and this particular slide says what I've just said. Specifically in terms of what you need to prove, I have set out a short passage here. You need to prove that first there was submission to arbitration. So of course the arbitration agreement and the fact of the arbitral proceedings and so on, and then the arbitration was conducted in accordance with the submission to arbitration, and then the award was a valid award, etc. And then there is this particular case example that illustrates the facts that under the common law enforcement, the court could go beyond the terms of the award in awarding damages and so on and so forth. And I'll leave the case here for your reference, and you could have a look when you have the time. And so after having talked about how you enforce judgments and arbitral awards, I'll talk about in the main these 5 grounds for refusing to enforce both foreign judgments and foreign arbitral awards. So the first ground is unfair procedures. But by unfair procedures, we actually mean a substantial miscarriage of justice in terms of, for example, there was no reasonable notice to the defendant. You just served the papers 1 day before the substantive hearing, 1 day before the trial. And then in the context of, I don't know, 2 or 3 days of trial. And even if that was permitted under the foreign jurisdiction's law of service, that might actually offend the Hong Kong court's notion of justice and fairness. And on that basis, the Hong Kong court may refuse to enforce either your foreign judgment or the foreign arbitral award. An example is here, Section 61A(3) of the HKIArb, which you have seen, and that is notwithstanding the fact that you might have served proceedings, the foreign proceedings in accordance with the foreign law of service, the defendant did not objectively have enough time to prepare and to appear, and in fact did not appear at the foreign proceedings. This is an live case example where actually the foreign court in that case was the Hong Kong court. So I think it was a Hong Kong master's decision, and then there was an appeal to a judge in chambers, and then the defendant was a litigant person who was not conversant in English, and then everything was in English, and then nobody explains his rights to him. He turned up at the hearing, and then the judge said that, oh, I'm not going to hear your substantive defense or submissions from the bar table because you haven't filed your skeleton, you haven't filed your affidavit in opposition in accordance with the usual procedures. So we'll still uphold the summary judgment, that sort of thing. And then subsequently, the plaintiff wanted to enforce this Hong Kong judgment in Canada, and then the Canadian court just said no. This offended my notion, the Canadian court's notion of substantive fairness, and then they refused to enforce the Hong Kong court's judgment. Now, in terms of the refusal or enforcement of Hong Kong or foreign arbitral award, the logic is similar. You have got to have a procedural unfairness of a substantial kind, and then of course in the arbitral process, and there was of course this particular requirement that you also try to resolve this procedural unfairness before the arbitral tribunal. So in other words, the court will also look at whether the arbitral tribunal attempted to rectify it or remedy the alleged procedural unfairness. And then if substantial procedural unfairness remains, then the Hong Kong court had the discretion to refuse enforcement. So I've also listed out some successful examples here. You can have a look at your leisure. But one example was quite extreme. So the respondent was imprisoned, and then papers had not in fact been served on him, and then the claimant lies to the tribunal and said that, well, actually, we have served the papers on him. That's the Sun Tian Gan case, the second last bullet point on this slide. So on those extreme facts, the court decided not to enforce the arbitral award. Now, another ground for the refusal for enforcing the arbitral award would be that the composition of the arbitral tribunal or the arbitral procedure was not in accordance with either the mandatory provisions of the arbitration ordinance or the parties' agreement. Again, for example, if the parties say that you have got to have 3 arbitrators, one on each side, to be appointed by each side, and then one would be appointed by, I don't know, the HKIAC, and then it turned out that one of the arbitrators was not appointed in accordance with that procedure, then there might be a ground for refusing to enforce the award. Now, turning to the second main ground of objection for enforcing foreign judgments and foreign arbitral awards, that is the lack of jurisdiction. Now, I foreshadowed that a bit previously, but what is meant here by the lack of jurisdiction is not the lack of jurisdiction under the foreign law, because presumably the foreign court would have been satisfied. A normal foreign court would have been satisfied that it itself has jurisdiction before rendering a foreign judgment in your favor. So what we are talking about here is whether the foreign court had jurisdiction in the eyes of, if you like, the Hong Kong law principles. In terms of enforcing a foreign judgment, the Hong Kong court would usually look at 2 main things: either whether the defendant was present in the foreign jurisdiction, either by way of physical presence or by way of residence, or whether the defendant had somehow submitted to the jurisdiction of the foreign court. So as you can see, these 2 points have been put on the slide. So either the defendant's voluntary presence or the residence of the defendant. The second point is the defendant's submission, either voluntary submission in terms of, there is a previous jurisdiction agreement saying that, whenever there is a dispute under the agreement, then we'll submit to this foreign court. Then, of course, there is an express submission. Alternatively, the defendant could have submitted by way of making a counterclaim or by way of persisting in the foreign proceedings up to the end of judgment without any protest. Then the defendant would likely be considered by the Hong Kong court to have submitted voluntarily to the foreign court's jurisdiction, in which case the Hong Kong court would say that, well, the foreign court would have had jurisdictions. Now, there are some other specific examples, but the point remains the same. So the Hong Kong court will need to be satisfied that under its own principle, the foreign court had jurisdiction. So, for example, the first bullet point here says that in Hong Kong, a foreign judgment will not be recognized if the foreign proceedings were brought contrary to a jurisdictional agreement. To say that, for example, in case of a dispute, we go to arbitration, and then you did that in breach of that, and you actually brought a foreign proceeding, and then B, the defendant did not agree to the foreign proceedings, so did not waive the arbitration clause, and did not counterclaim in those proceedings. So if you have these requirements, then the Hong Kong court will not recognize the foreign judgments. Now, the regime under the FGREO are effectively the same. So the FGREO would also like you to satisfy that the defendant had been present in the foreign jurisdiction or had submitted to the foreign jurisdiction effectively. They are worded more specifically in the last 2 bullet points in this slide, but the logic is largely the same. And the residence-based jurisdiction, all these, etc. Now, what if your proceedings concern immovable property? I have alluded to the fact that if your immovable was located in that foreign jurisdiction, then by the usual conflict of law rules, then the foreign court would have jurisdiction, less citus. But under the FJREO, there was the reverse situation where the FJREO would say that if, for example, the immovable property was actually outside of the foreign court's jurisdiction, but the foreign court somehow still lay its hand on that immovable outside of jurisdiction, then the FJREO would deem the foreign court not to have the jurisdiction. So that's the reverse situation. And there is one last situation under the FJRU, and that is the defendant was subject to or was entitled to the benefit of immunity under public international law rules, but still the foreign court said that I'll hold it against you. So the foreign judgment was given in breach of the judgment debtor's immunity. Then the FJRU would also not recognize the jurisdiction of the foreign court. Now, in terms of arbitration, this ground of lack of jurisdiction looked at whether the award has gone outside of the scope of the submission to arbitration. So, of course, there are two levels. The first level is, of course, the fundamental arbitration agreement. So what does the arbitration agreement in the contract that says, that specifies the scope of arbitration? And then the second layer is for this particular arbitration, what it is that you have submitted to the tribunal for decision. So what is the precise scope of this particular dispute? So for this, you will look at the parties' pleadings, but also you will look at the parties' affidavits and so on. So only if after you have looked at everything, that's the scope of the arbitration award actually exceeded the submissions or the scope of submission to arbitration, will you make out this particular ground? So I have set out some examples in real cases. Now I'll just mention Wah Chang. It says here submission to arbitration only covered disputes on condition or quality, but not on alleged failure to open letters of credit. So it is the submission under the arbitration agreement that make the arbitral award go beyond the scope of jurisdiction. And in that situation, of course, then the court will not enforce the award. But of course, there is this residual remedial method. If part of the award was in excess of jurisdiction and part wasn't, and the part in excess of jurisdiction could be severed from the part that was within the jurisdiction, then the court would do their best to enforce the part within the jurisdiction. So there are some other points as well under there, and I'd like very quickly to talk about fraud and then the other two, and then I'll wrap up for some Q&A. Being conscious of the time, but in terms of fraud, you need to remember that it has got to be fraud either of the other side or of the court or tribunal. So either the plaintiff was the fraudulent party or the court was corrupt, and you have got to have things like real fabrication of evidence or evidence of corruption on the part of the court in order to make good this ground. And as with other fraudulent allegations, you've got to particularize and then establish it to the requisite standards in order to make good your case on fraud. Otherwise, it would just be too easy for you to say that, oh, they are dishonest, and then to resist enforcement. Now, the fourth ground is lack of finality. That also ties into the fundamental requirements, either for foreign judgment or foreign arbitral award, that you have got to have final and conclusive nature in order for you to enforce it in the first place. So we talk about final and conclusive. What does it mean in reality? Now, this particular slide has one important point. Clearly, a judgment or order which is said to be nisi or interim judgment is not final. But that doesn't mean to say that some other interlocutory judgments are not final. So I'll show you some example. Now, for example, default judgments. Default judgments, you could say it is interlocutory insofar as the other side might still try to have a goal to set it aside in the same court. But for as long as it still stands, then it is to be regarded as final and conclusive. Otherwise, people would just be absent from the foreign proceedings and then turn up at your enforcement stage and say that, well, I didn't participate. Consensus judgments, all the more reason to say that they are final and conclusive. Now, summary determinations of standard issues. So if you get a summary judgment, you will think that it is final and conclusive. Now, that's easy and to understand. But what if it is a refusal to give summary judgment or a refusal to strike out proceedings so that the foreign proceedings continues? Now, in those situations, then the decision will not be final and conclusive. So you can't take that to Hong Kong to enforce. Of course, there is nothing to enforce in those stages anyway. And similarly, judgments entered by virtue of procedural defaults, like default judgments, they should be considered in principle to be final and conclusive. Now, in terms of the lack of finality, there is also this situation of appeal. And so in gist, unless and until you have a foreign appellate court setting aside the foreign judgments, the Hong Kong court will not necessarily set aside the Hong Kong enforcement of the first instance foreign judgment. The Hong Kong court may still give you registration, may still give you recognition, but they may say that I will stay execution in Hong Kong pending the foreign appeal. So that is the effect of these slides that I've put down there. And then there are some other discrete grounds of refusing enforcement of either arbitral award or foreign judgments that are put in here that unfortunately we haven't got sufficient time to cover today. So so perhaps I'll now turn to the Q&A, if I may.
Certainly, Thomas, thank you so much for your sharing. Okay, of course, as I said before, I encourage participants to put forward your questions in the chat box. Well, I have to say that as a moderator, it's my privilege to ask the first question, if I may, Thomas. Okay, well, as you share with us that upcoming, there will be a new piece of legislation, the Mainland Judgments in Civil and Commercial Matters Reciprocal Enforcement Ordinance, Cap 645. Well, as a petitioner, I trust we all would like to know more what implications or otherwise difficulties petitioners may have to embrace this new upcoming piece of legislation once Cap 645 be enforced.
Yes, thank you, Ward, for this very good question. Now, I'm just trying to share back the screen so that everyone has the materials before them. Sorry, so it should be this. I think it should be this one. Yes. So now, if we look back at here, the regime actually removes a primary difficulty in not requiring an exclusive choice of mainland court agreements in your jurisdiction clause. So one difficulty has been removed, and it also applies to other non-monetary kind of judgments. So those are also taken care of. Now, I suppose what is important would be for practitioners to have in mind some of the landmines in terms of what mainland judgments are not covered. So we can have a look here. Corporate and individual insolvency, bankruptcy and compromise matters are not covered. Succession and then family, and then some IP cases and rulings, maritime matters, interim measures. So unfortunately, if there is an interim injunction, it can't be enforced here. As usual, you've got to ask for mirroring relief under, for example, Section 21M or whatever case you've got, and punity of exemplary damages. So these are the if you have a judgment to under one of these categories, then this particular new piece of legislation will not help you. And then other than that. The other thing to bear in mind is that if you can see this particular slide, I'm sorry, this may be a little bit small in print, but the courts that are in question would be the courts, the Supreme People's Court, the Intermediate People's Court, the Higher People's Court, and some recognized Basic People's Court. Under the new legislation, the amount of courts recognized are still the same. So if you have a random Basic People's Court, it may not be recognized even under the new regime. So these are some of the pitfalls that we may need to be worried about.
Thank you so much, Thomas. I can see that there are some questions put forward by participants. Perhaps let me perhaps read this out. If there's a mainland judgment, theoretically it can be retried, whether it's a final and conclusive under the Hong Kong law.
Yes. Now, thank you very much for that question. I think in a previous version of these slides, I have actually included a particular case example addressing specifically this question. But I think the short answer to that is that the Hong Kong court will not automatically set aside or refuse to enforce a mainland judgment if it is otherwise enforceable in Hong Kong, simply because it could, in principle, be retried. So what you need would be something more. You would actually have made an application for retrial, and then the Hong Kong court would then see the specific circumstances to decide whether execution in Hong Kong should be withheld, or whether actually the Hong Kong court should do more by stay, for example, I don't know, staying the Hong Kong enforcement proceedings until the mainland retrial issue has been resolved. So in that sense, it is not unlike the situation of appeals. For appeals, it is also not an automatic ground for refusing enforcement or for setting aside enforcement. It is only, if you can see the slide here, it is only, and in the fourth scenario here, when you have an actual appellate court judgment that actually sets aside the original foreign judgment, that the Hong Kong court will refuse enforcement of the original foreign judgment. So I suppose the logic would remain similar for the mainland judgment that is acceptable for retrial.
Thank you so much, Thomas. Another question for you. Let me read this out. You mentioned the rules of international jurisdiction, which requires presence or submission of the defendant to the jurisdiction of the foreign court for the recognition and enforcement of judgments from that court. There's some discussion in England, mostly academic, about whether that is that is the correct test, or whether presence should be replaced with residence. So do you have any similar discussions? Do you know any similar discussions in Hong Kong?
Yes. Thank you very much, Josh, for that question. Actually, Josh is my colleague. I think the answer to that in Hong Kong is that as far as the common law is concerned, enforcing judgment in common law is concerned, I think I have the slide here. Residence is a possible means of establishing the presence of the defendant and therefore jurisdiction under the eyes of in the eyes of Hong Kong law, and that is a possible, possibly correct or possibly incorrect legal position under Hong Kong law. We don't have an authoritative appellate authority on that yet. I don't believe. But in terms of the statutory regime for enforcing foreign judgments in Hong Kong, we actually have a provision, I think. Yes, we actually have a provision, which is the first bullet point in this slide. This is taken from the FJREO, so it applies to those foreign jurisdictions. And it says that if the judgment debtor was at the time resident in the country of that court, then there would be jurisdiction of that court. So for the statutory regime, it is entrenched in the statute. For the common law regime, well, it's an arguable position. We don't have an appellate authority, so probably it is a good thing if you ask me honestly, because it is an additional ground for recognizing the foreign court jurisdiction.
Okay, thank you so much, Thomas. I can see that now is only 30 seconds away from 7 p.m. Well, thank you so much, Thomas, again. When I introduced you to the participants, I forgot one particular highlight of yours, because you also share with us that I trust all participants may not know that Thomas, he enjoys cycling and traveling. I confess that these two things I also enjoy so much, especially Thomas and I share the same situation that we just head back from Europe recently, right? So thank you so much, Thomas. I have to put my hands together again to appreciate your sharing this evening. So of course, all of the participants, please take a chance to put forward your assessment, your evaluation form, so that we can have overall improvement down the road. Okay, thank you so much, Thomas, again. Thank you.
Thank you very much, Wong. Thank you very much for listening. Thank you. Have a
Thank
good
you.
evening.
Thank you. Thanks a lot, Sui. Thank you.
Thank you. Thank you.